Hi everyone, my name is Kenneth Matuszewsky, and I am an associate at Rabicoff Law, LLC. Today, I'll be talking to you about the basics of intellectual property. There are three basic takeaways I want to show from this video today. First, that intellectual property in general is a creation of the mind that's used in commerce. Second, patents give inventors an exclusive right to their inventions or ornamental designs for a limited period of time. And finally, that trademarks identify and distinguish the goods or services of one business from another. We're first going to talk about patents a little bit. So we need to know, what exactly do patents do? Well, they promote the progress of the useful arts, and the useful arts include machines and other types of manufacturing equipment, by giving inventors an exclusive right to their inventions for a limited period of time. And there are two types of patents in general. First, we have the utility patents, which protect objects or processes that can be used and generally last for about 20 years. Second, we have design patents, and those last for 15 years. And design patents protect the ornamental appearance of an object. So say if maybe you had the base of a lamp that was shaped like a circle, you'd be able to protect the circular shape of that lamp. Now, what can patents be used for? And generally, what can you get a patent for? You can get a patent for just about anything under the sun, as the Supreme Court mentioned in a few cases, apart from a few exceptions. I'll be talking about these exceptions in later videos. So what does your invention need in order to obtain a utility patent? I realize for the sake of simplicity that I will be focusing on utility patents today because they are more common than design patents. So there are four basic requirements in order to obtain a utility patent. First, you must have patentable subject matter. Second, you must have utility. Third, the invention must be novel or new. And finally, your invention cannot be obvious. So what can we do with the patent? Well, first, if you're the patent owner, you can sue competitors in your industry who are using your patented technology. Second, you could potentially enter into a licensing agreement with someone you think is copying your invention. And by doing so, they would pay you a small fee known as a royalty rate in order to use your invention. Or finally, say for example the utility patent, after it expires in the 20-year period, you can actually build off your previous invention, since it's public knowledge, and further develop and promote the progress of science in general. Now we're going to talk about trademarks a little bit. So what does a trademark do? It identifies and distinguishes the goods or services of one business owner from another and indicates the source of those goods. Probably one of the most famous examples is McDonald's. Now you've seen the McDonald's logo, the golden arches, just about everywhere. But think about it. It helps you identify that you're going to a McDonald's, right? You're not going to a Burger King or a Wendy's. You know right away from those arches that you're taking a trip to McDonald's. And there's a few different types of trademarks that can be obtained. First, we have a generic trademark. So you actually cannot receive any trademark protection at all if it's considered generic. Some examples include shredded wheat and aspirin. And shredded wheat and aspirin became so commonly known in the public domain that courts thought that people should not be able to have exclusive rights over those words. Second, we have descriptive marks. And this is going to be a majority of the trademarks out there. And these are weak because they actually describe the goods or services associated with that mark. So any type of descriptiveness, such as a cookie business, which tries to call itself hot and ready for cookies that are sold very hot and freshly baked. That just describes how the cookies are made. And finally, we have arbitrary and fanciful marks. And these are the strongest types of trademarks because the mark is ordinarily not associated with that good or service. Apple is a very good example of this. Now, when you first think of the word apple, you probably think of the food that you used to eat, that you not only used to eat, but you still do. Apples are a delicious fruit, and they're a great source of nutrition. When the Apple company was first starting out, they actually had the great idea to have the word apple be associated with the computer. Now, a food and an electronic good is in no way associated with each other. So, in other words, you have to have almost a leap in logic to associate the word apple with the computer. So what can we do with trademarks now? Well, we can enforce them. You can go after companies that are selling products or services that are very similar to yours. So say, for example, if maybe if we're taking the Apple computer, for example, and a competitor tried selling a Bapple computer, well, then customers might be confused about which type of computer they're buying. But the interesting thing about trademark law is that you don't actually have to prove that people were actually confused when they were maybe looking at these products or considering buying them in the first place. Also, you can modify or change up your trademark a little bit, as long as people still generally associate it with the goods or services. Think about the evolution of the Coke logo. Over the years, we've had maybe some of this. Santa's been featured, or the polar bears. There's even been changes in font, size, color. But people have still associated all those changes with the cola that Coca-Cola sells. To learn more about the benefits of joining our ISBA Intellectual Property Section Council, please visit the ISBA website. Thank you.